we are going to be now joined by J Sai Deepak, advocate in the Supreme Court. And the context is very simple. Today, the Hindu side has approached the Supreme Court. Why has it approached the Supreme Court, viewers? It has approached the Supreme Court because it wants now a scientific ASI survey to be conducted on the Wazoo Khana, and in specific, a shivling-like body that has been discovered there. Now, viewers, this has elicited a massive backlash with many people, many tolerant, secular-minded Indians who have kept quiet, of course, on the Dr. Ilyasi matter, but they have come forth on this and said that this is ultra-virus of the Indian Constitution, of the Indian legal system. It is ultra-virus of the Placer Worship Act 1991. And they go on to say that any move to reclaim Gyanvapi, which they have associated with this demand for a survey, is also illegal therefore. So I want to speak to J Sai Deepak, who's done some work on this particular issue. J Sai Deepak, thank you very much for joining me this evening, for joining our fraternity of viewers this evening. I just want to very quickly, viewers, just run you through the demand here of what has been suggested. Basically, viewers, this move has come on the back of an ASI report that has been recently released as late as Friday last, to suggest that there are a large number of Hindu structures underneath the Gyanvapi mosque, and therefore the Wazoo Khana containing the shivling-like structure must also now be examined. J Sai Deepak, unfortunately, we've had a backlash. Many people are saying, no, you can't do all of this. You can't go around shoveling under mosques, etc., to determine character, this, that, the other, because there is something called the 1991 Placer Worship Act. Could you explain to our viewers, because you believe that it isn't actually something that should even be considered an obstacle, why?
So, first of all, I'd like to congratulate Shri Vishnu Shankar Jain for the stellar work that he has done, for his perseverance in pursuing this hard battle, this onerous task, and for actually swallowing this poison of hatred that's coming his way. Rest assured, I'd like to place on record my absolute appreciation and support and encouragement for his initiatives. And I hope him and others don't stop, or he and others don't stop with Kashi. There are other places to be reclaimed. Now, coming to the question, I don't think there is a legal bar. Let me rephrase it. There is no legal bar. Okay? If you were to go through the provisions of the Places of Worship Act, the POW Act, which I call also the Prisoners of War Act, okay, there are only 7 provisions, out of which the 7th provision is a repealed one. So effectively, there are only 6 provisions. The provision in question that enables whatever Vishnu is doing and the maintainability of the action insofar as Kashi is concerned is section 4. Okay. So there are only 2 sections which are strictly relevant to the issue of so-called bar on reclamation, section 3 and section 4. Section 3 speaks of bar on conversion of the place of worship or its religious character. But section 4 says that while you can certainly preserve the religious character of a place of worship as it existed on 15th of August 1947, the exception to this is section 4.3, which clearly says section 4.3 actually has 3 different components, one of which is that if you're able to establish that the site in question is an ancient monument or an archaeological site and remains, then the bar under section 4 shall not apply, which means that the requirement of status quo of the religious character of the temple under section 4.1 or 4.2 will not apply if you're able to establish under 4.3 that it is either an ancient monument or an archaeological site and remains. Now the good part is these terms have been used in relation to the 1958 Act, which deals with ancient monuments and archaeological sites. Okay. Now there are 2 sections in it, sections 2A and 2D, both of which define, or each of which define, what is an ancient monument and what is an archaeological site. The simple test is if something is older than 100 years or old, or older, so to speak, then it immediately becomes an ancient monument or an archaeological site within the meaning of 4.3. Automatically, 4.1 and 4.2 do not apply. Okay? So, simply put, what is it that we are talking about? If I am able to undertake a carbon dating of a particular structure which I wish to reclaim, and I say that this is more than 100 years old, this is what the science establishes, and there is enough material to show that its original character is not the present character of the place, then I can file proceedings for its reclamation, I can lay claim to it. The Places of Worship Act and no provision of the Act will come in the way of that recovery proceeding. Okay, that's exactly why Vishnu, according to me, went about it in a systematic fashion by asking for an ASI survey to first of all find out what is the structural evidence or archaeological evidence underlying that so-called disputed structure. And the second thing is, let us date that particular underlying structure to find out whether it is more than 100 years old. Okay. The good part is, even if you don't date it, there is enough primary source to basically establish that the structure beneath has been recognized in gazetteer records and colonial records to be at least 100 years old, if not more. Okay. Therefore, for all practical purposes, two things are established. One, there is no legal bar to the maintainability of the civil suit that he has filed for recovery of the Kashi Vishwanath Mandir. Point number one. The Places of Worship Act does not come in the way of that. Okay. Two, the ASI survey report has proven to be the smoking gun, which is exactly why people are busy rubbishing and dismissing it without any basis. Again, the same factory, this cottage factory, which swung into action in the 1990s, and in 1989 onwards, when the Allahabad High Court had started directing excavation of the site, which was previously known as the disputed structure in Ayodhya, okay, that same cottage factory has swung into action. Point number three, I know of enough geniuses who constantly say that the Places of Worship Act is immune from challenge because the Ayodhya verdict, the Constitution bench, has effectively said that this particular legislation upholds the shining star in the constellation of constitutional values, namely secularism, and therefore you cannot even challenge it because a constitution bench has given its seal of approval.
Yeah, I was going to ask you that question. Now, how do we, now at least, okay, fine, in letter, you say that if a structure is deemed to be more than 100 years old, the Places of Worship Act doesn't apply. But
correct,
the Supreme Court judgment seems to at least uphold in spirit, I'm not saying letter, in spirit, the Places of Worship Act 1991 with a view to ensuring communal harmony and the provisos of the Constitution that apply to the preservation of our secular ethos. How do we get around this?
So before I answer that question, let me just, let's say, advertise myself a bit. I have written an article which was published barely a few days ago, I think on the 24th of January, explaining this position in the Open magazine, capturing my arguments in detail with respect to the Places of Worship Act, giving three different layers of arguments as to why none of those provisions come in the way of reclamation of sites such as Kashi and Mathura. And allow me to say this, my position, and I agree with Vishnu on this, and I think he agrees with me on this, is that we are not just looking at Kashi and Mathura, we are looking at 40,000 sites across the board. Because no one can make a concession on behalf of anybody else. It's like saying, Rahul Shiv Shankar has a dispute with his neighbor on ownership of property. Sai Deepak steps into the picture on behalf of Rahul Shiv Shankar and says, you know what, let's maintain peace and harmony. I will concede this land on behalf of Rahul Shiv Shankar. Who am I to do that? Right? It's a property dispute. It's an ownership of religious property. Therefore, no third party, even if he happens to be or they happen to be the representatives of Hindu or Hindutva according to them, can make any concession on behalf of those interested in reclamation of these sites because it is for the devout, it's for the owners of the property to reclaim. Nobody can make that concession on anybody's behalf. So let the clarification come on record. Now let's answer your question. Bear with me for the answer that I'm about to give on the Ayodhya judgment. I will walk you through the problems of that judgment and explain why it makes no sense whatsoever to cite that judgment as coming in the way of this legal action. First, the first principle of law is if an issue has never arisen for consideration in a judgment, then any, let's say, observations on that issue don't constitute legally binding findings. Okay? Which means the Places of Worship Act was irrelevant to the Ayodhya dispute. Why? Because Section 5 of the Places of Worship Act says nothing in this act applies to the Ram Janmabhoomi proceeding. Okay? If no provision of the act and the act itself does not apply to the Ram Janmabhoomi proceeding, then no provision of the act was ever up for challenge or question or scrutiny or adjudication before the Ayodhya bench. Okay? Therefore, all the 10 paragraphs on which, according to me, respectfully, ink was wasted in discussing Places of Worship Act and its so-called contribution to this grand Indian philosophy called secularism, or imported philosophy called secularism, according to me, have no role to play. It has no force of law. It is not legally binding. It has no precedential value. This is an irrefutable position of law.
No. Okay.
On this, I have written at least 4 articles in the immediate aftermath of the Ayodhya judgment. This is not an afterthought of an argument. I've been writing this for 4 years because I realized that while the judgment was being written, the effective argument being made in the judgment was, we will give you one temple while we will shut the door for recovery for other temples. Okay? Unfortunately, the law remains the same regardless of who authors it and who says it. Therefore, nothing in the judgment comes in the way of recovery of Kashi, Mathura, or 39,998 temples. Point number 1. Point number 2. The discussion on the Places of Worship Act in the Ayodhya judgment is a factual error. You know why? That discussion is triggered by the Constitution Bench's mistaken understanding that the Allahabad High Court dealt with the Places of Worship Act in its judgment of 2010. I went through each of the judgments of the 3 judges of the Allahabad High Court, Justice Sharma, Justice Agarwal, and I think Justice Khan. I went through all the 3 judgments. None of them discusses Places of Worship Act.
Right.
The Constitution Bench effectively lays the foundation for its discussion on the Places of Worship Act, saying, since the Allahabad High Court has discussed it, we have to discuss it.
Right.
The Allahabad High Court did not do it. The Allahabad High Court cited a 1995 judgment called the Marthoba judgment, in which the Places of Worship Act was extracted. Okay. So it was actually an error of reading. I wrote an article to this effect in the New Indian Express, and I was asked to stop writing on the subject later.
Okay, I won't get into that part of the story, why you were and who pushed you. I can get a bit of a sense because I know of the censorship that exists in the media when people actually come up with strong arguments challenging the mainstream narrative. But J Sai Deepak, this has been wonderful as always speaking with you. It's always good to get a deep, well-researched insight. I'll take a short break. Thank you very much. Thank you very much. We'll take a very short break. We'll be right back. Don't go away.